Hindering the removal or modification of fortifications is an offence under Section 210E of the Law Enforcement Powers and Responsibilities Act 2002. The LEPRA, which carries a maximum penalty of 12 months in prison. To establish the offence, the prosecution must prove beyond reasonable doubt that 1. A fortification removal order was in place in relation to a particular property, and 2. You engaged in any act intending to prevent, obstruct or hinder the removal or modification of fortifications in accordance with the order. A fortification is defined as any security measure that involves a structure or device that forms part of or is attached to a premises that 1. Is intended or designed to prevent or impede police access to the premises, or 2. Has or could have the effect of preventing or impeding police access to the premises and is excessive for the particular type of premises. Section 210C of the LEPRA provides the Commissioner of Police with the power to apply for a fortification removal order under the provisions of Part 4 of the Local Court Act 2007. Any notice of such an application must be personally served on the respondent or, if personal service cannot be promptly effected, affixed near the entrance of the subject premises. The offence of hindering the removal or modification of fortifications applies to actions being undertaken by any owner or occupier of the subject premises, as well as any person acting on their instructions. Section 210D provides that, in the event that a person fails to comply with a fortification removal order, the Commissioner of Police may cause the fortifications to be removed or fortified in accordance with the order. In that regard, the Commissioner or any police officer authorized the Commissioner may a. Enter the premises without a warrant. B. Use reasonable force to enter the premises. C. Use such assistance as considered necessary to facilitate compliance with the order. D. Seize anything required to be removed for the purpose of compliance. Or E. Do anything else reasonably necessary to ensure compliance. The Commissioner may recover the costs of any actions required to facilitate compliance with the order, and the Crown does not bear liability for any damage resulting from those actions. However, a notice must be served upon the respondent not less than 7 days before entering the premises that 1. Contains a summary of the fortification removal order, and 2. Specifies the intention to enter the premises to facilitate compliance with the order. General legal defenses to the offence include duress, necessity, and self-defense. If you are able to raise evidence of a general legal defense, the onus then shifts to the prosecution to prove beyond a reasonable doubt that the defense does not apply to the circumstances of the case. You are entitled to an acquittal if the prosecution is unable to do this.
Going to court. Call Sydney Criminal Lawyers on 9261 881 to arrange a free first conference. Watch our latest video here.